Well, welcome back. We're going to go ahead and get started with our second panel. My name is Scott Skinner-Thompson. I teach here at Colorado Law School. And our first panel, as you know, focused on federal interventions with respect to privacy. And this panel is going to focus on the purported
Everybody turn off devices for not speaking.
laboratories of democracy, the states and localities. And we have a great lineup following up on the first great panel that includes several experts currently focused on policy at the state level. To my immediate left is Daniel Castro, who is a vice president at the Information Technology and Innovation Foundation. To his left is Rebecca Krutoff, a professor at Richmond Law School. To her left is Daniel Pietragallo, who is an assistant attorney general in the Colorado Attorney General's office. To Daniel's left is Ashkan Soltani, who's an independent researcher who helped draft the Ccpa, which you got a brief introduction to in the earlier panel, but we'll discuss more in depth shortly. And finally, at the end of the table is Gabriela Zamfer Fortuna, who works at the Future of Privacy Forum. As we learned in the first discussion, the privacy problems we're facing today are myriad, they're multidimensional, and there's lots of different ways of thinking about them. Certain localities are starting to take certain kinds of privacy threats very seriously. Cities like San Francisco and Somerville, and I just read this morning that Portland is considering bans on facial recognition technology. The bans so far have focused on government use, but the Portland proposed ban would also prohibit private sector use of facial recognition technology. So Rebecca, to get us started, I thought you could maybe talk to us about this kind of regulation and where it's stemming for, and related to some of your work, how it relates to bans on certain kinds of weapons, including autonomous weapons systems by different government entities.
All right, so hi, thank you so much for the opportunity to be here today. As you noted, I study when and how the law of war, the rules of war, can constrain state action with an emphasis on new technologies, new weapons technologies. And I've been particularly interested in the question of when bans can be successful. So we're going to review a couple of factors and see if we can extrapolate out to something that's also useful in the facial recognition context. I want to clarify, when I say the word successful, that can be defined a lot of different ways. I tend to use it as bans that are both negotiated, right? So they go through, they become rules in some way, either through treaty or, in the case of facial recognition, statutes, and effective. They're actually effective at decreasing the use of the thing they're talking about. And in doing so, I have studied everything from the ban on crossbows, which was pretty much broken from the moment it was proclaimed in 1096, to chemical and biological weapons, to the ban on permanently blinding laser weapons, which is the most successful ban of all time insofar as there has never been a recorded violation of it. I teased out 6 themes looking at these factors that might be relevant here. All right, so first, passage of a ban often requires significant civil society engagement. When does that happen? Usually after the publication of a huge tragedy or accident in some way. So for example, the first ban on chemical weapons was the 1925 Geneva Gas Protocols, which was in response to photos and stories of World War I gas initiatives. So the sort of civil society mobilization coming in response to a huge tragedy or an accident that then is well publicized and known about. 2, countries tend to buy into bans when there's also an alternative means of accomplishing the same objective. So they're tying their hands in one way because they're not actually reducing their ability to engage in the activity that they ultimately want to engage in. They can still achieve their same goals. The example here, permanently blinding laser weapons, the ban on them has been so successful in part because it doesn't ban temporarily blinding laser weapons. So you can blind a group of people for a short period of time, just not permanently. Accomplishes the same goal in combat. 3rd, there's often country buy-in when it's clear that the use of the technology can harm everyone or the effects cannot be controlled. So example here is biological weapons, right? You can field biological weapons, but it's really hard to guarantee that they're not going to also affect your own troops and hurt you back. And so there's something useful in everybody choosing to tie their hands over the use of biological weapons. Turning to effectiveness. Part of the effectiveness of a ban depends on whether or not violations can be identified, whether or not you can trace when it's happened and therefore impose punishment or censor the user. This is a really big deal for chemical weapons, where the forensic evidence of the use of chemical weapons is critical to the enforcement. Number 5, effectiveness can often depend on understanding the underlying technology and its constraints when you craft the regulation or the ban. This is really important and complex, so here's the example. There was a ban on the use of submarines in warfare unless they acted like other military warships. And the requirement for military warships was that if a military warship was going to sink a merchant ship that was armed, it could do so, provided that it either, 1, escorted the ship to port, made sure that all the people got off safely, and then sunk the ship, or 2, took all the individuals, took all the people and passengers on board, and then sunk the ship. You take these rules that were crafted for the architecture of warships and try to apply them to submarines, and it doesn't work, right? Submarine success depends on stealth. If the other ship knows where they are sitting targets. They cannot possibly escort a ship to port. 2, submarines are a little cramped. They cannot take on a bunch of passengers before sinking a ship. And so a bunch of states nobly tried to comply with this law for a little bit until everyone basically saw that it didn't work, and then everyone flouted it completely and established this new customary law loophole of submarines had to act like warships, except A, B, C, D, E, F, G, H, I, J, K. And so something when you're crafting regulations, you've got to take the architectural constraints of the technology into account, what it can or can't do. And sometimes that's going to require not just taking an old rule and copy-pasting it onto a new situation. And 6, definitions are critical. And sometimes success, defined as I said, effective, negotiated and effective, might not actually be success in terms of accomplishing your ultimate goal. So what do I mean here? Well, the ban on permanently blinding laser weapons was successful because they were essentially defined out of existence. Right? It was so narrowly tailored, so narrowly crafted. It allows for temporarily blinding laser weapons. It also allows for weapons that unintentionally blind people, right? That have a side effect of blinding people, permanently blinding people, as long as that's not the main goal. And so the ban was successful, but it doesn't actually solve the problem of permanently blinding people with lasers in warfare. This is a huge problem right now for the use of AI and autonomous weapon systems. There's a ban that's being discussed at the convention for certain conventional weapons. And whether or not that ban is going to be successful, it sort of depends on what the end goal is and how we define autonomous weapon systems. If we define them for the purpose of banning them as berserker killer robots that are completely uncontrollable, going to get a ban passed probably. No state actually wants to field berserker killer robots that are completely uncontrollable. But whether, and it'd probably be a very successful ban, but whether or not that's actually going to accomplish the goal of addressing the problems raised by increasing autonomy in weapon systems, no. If you define them instead as weapon systems with the capability to recognize, select, and engage targets without human intervention and use lethal force, well, then you have to recognize that about 30 different states are already using those types of weapon systems today, which is going to fundamentally change your stance on whether or not, how to regulate them. And so the overarching point here is that definitions are critical, and you don't want to get into the position of defining something so narrowly that you lose the ability to accomplish the goal that you're actually trying to achieve with the regulation. The idea that this is about the future of tech privacy, sorry, about the future of technology and privacy, I just had to leave with this quotation from Stephen Colbert, that there's an old saying about those who forget history. I don't remember it, but it's pretty good. And it seems relevant.
So super interesting. Thank you, Rebecca. Just by way of follow-up, I mean, taking your, I don't know that we need to go through all of the principles, but applying some of those to efforts to regulate facial recognition software, where do we stand? I mean, at least with regards to the other means to achieve the goals, from a law enforcement perspective, I mean, I think it's my sense is that we don't have huge problems finding people that we think have engaged in potential wrongdoing, that our law enforcement system already has lots of surveillance tools, and our laws are not enforced in a dramatic way. Does that resonate with you? What do you think about the other factors as applied to facial recognition?
Yeah, I mean, I think so the goal of articulating these principles was to be of use in crafting the conversation. So if advocates of regulation on facial recognition, I think it's to their benefit to highlight the fact that there are other means of accomplishing similar goals. Sometimes they won't be as fast as easy, but those trade-offs can be worth it for various other rights-respecting reasons. The issue, of course, with making that kind of argument is it sort of implicitly endorses the other forms of surveillance, which my sense is most of the advocates against facial recognition are not going to be as comfortable doing. So trying to find that line, that's the challenge.
Yeah, absolutely, and it buys, I mean, to Ryan's earlier point about language and rhetoric we choose, I mean, it also buys into the notion that we need to have a mass incarceration system in the first instance. Daniel, turning to you, and facial recognition bans more squarely, what do you see as the major costs and benefits of attempts to ban the use of this technology either by law enforcement or in the private sector?
Sure. So I think first when we talk about facial recognition, I think the conversation right now treats it as this kind of monolithic technology or as kind of one use case. But there's really a huge variety of uses of facial recognition just in general. And then, of course, within law enforcement itself, there's lots of different applications. And so part of what's troubling about, I think, the calls for bans on facial recognition is we're not only talking about, I think the thing that most people are concerned about is this idea of completely pervasive camera network that's tracking where everyone's going. And so you have a longitudinal data about every place everyone's ever been for all time, and that's what we're trying to avoid. But on the complete other end of that, we also have things like literally you have a photo of someone, you're just trying to figure out who this person is. It might be a witness, it might be a victim, it might be someone who was arrested without identification. You're simply trying to identify this person. There's lots of uses of identification currently where there's a manual process of trying to identify somebody based on photos. And there's a question of, well, can we just automate that? A very simple process. Can we automate something that humans do today? There's also the issue of, can we use facial recognition to verify somebody's identity if there's a police encounter or when somebody's coming into a secure facility? Then there's things that are kind of in that a little bit further more towards that real-time surveillance of identifying victims of sex trafficking. So looking, for example, at online ads and going through and data mining some of these types of data sets to identify potential victims, looking for missing children or elderly adults. Maybe that's going to be something that's used with some real-time uses. And then, of course, there's the kind of real-time shooter or a Boston, marathon bomber type situation where there's somebody, that you're actually trying to identify either in a public place or in response to a crime. So there's lots of different uses. And one of the problems with the ban is, it bans everything across the board. And I think that's troubling. I think when we're talking about bans on facial recognition, we need to recognize that for the most part, these are going to be moratoriums. I don't think, there are some things that we've, decided to completely ban permanently. Certain hazardous chemicals, maybe plastic straws, right? There are things like that that in the future might no longer exist. I think it strains, credibility to say that, 10, 15 years from now, we will not use computers to identify people. And as in certain encounters, that will happen simply with the progression of computer vision that's getting increasingly better in a variety of cases. What will likely happen is that we'll have rules and regulations around how that's done. And so one of the problems that we have with bans is it constrains the advancement of that technology in, I think, ways that would actually be beneficial to some of the concerns that people are raising. So, for example, one of the main concerns that's been raised is that the technology isn't as accurate as we would like it to be, particularly for certain minorities and women. And so, if you want to address those issues, one of the ways to do that is to have government be an early adopter, but under the conditions that it's setting the conditions for when it will procure that technology. It is providing strong oversight over the performance of the technology, and it's making that information public. So commercial adoption also follows in those same areas. So I think there's a lot we can do besides bans. I think the conversation over the past 3 months has been, bans have taken off because we have seen these 3 cities do it. Overall, Pew actually just released a survey yesterday. Only 15% of Americans were saying in that survey that it's acceptable that it's not acceptable for police to use facial recognition for safety. We did a poll back in December, and it was a similar question. 18% agreed the government should restrict facial recognition if it comes at the expense of public safety. So when you start asking people about facial recognition in this context, there's actually not a lot of objections. When we did our survey, we actually asked questions also about surveillance cameras, and it turned out that the main objection people had is actually to the surveillance cameras being there. It was less about, and then you add on facial recognition. So I think there's an important conversation that's going to happen in this space. When we talk about cost, though, which was just to your original question, we have to think about I think the operational cost in terms of the impact it will have on safety and efficacy. There's the efficiency cost, so the actual tangible cost of doing things on a manual basis instead. And then there's also, I think, the innovation cost, which is something my organization focuses a lot on. I mean, we are seeing other countries moving ahead in these areas. This is a key area of computer vision and machine learning. The United States wants to do well in AI. We need to be early adopters in these areas, but we need to do it in ways that are responsible. So I think the better option is to say, how can we do this responsibly? Can we have performance requirements? Can we have oversight and restrictions on certain types of uses that we find problematic? Can we try and have really strong warrant requirements for if you're doing geolocation tracking? There's a lot of conversations we can have around those types of issues that aren't about bans.
Did anybody else want to jump in on this topic? I mean, one question I have for you, Daniel, I mean, just to situate it a little bit more, I mean, take for example, a large social protest, right? So lots of people are going there, and traditionally we've felt anonymized by the crowd itself, right? And the crowd, we feel safe, we feel protected by the presence of others, and that's critical to the freedom of speech and the freedom of assembly, as scholars have noted and the Supreme Court has noted. So what happens in a world in which the Boulder Police Department is able to have cameras and just record everybody that's at a public demonstration, and then subsequently identify everybody that's at that presentation? Is that an example that you think falls within the core public safety context that should be permissible, or is that chilling on the freedom of assembly and expression.
Yeah, I mean, I think there's a lot of problems with police being at protests. I mean, you know, the argument is they're there sometimes for safety, and they record these things sometimes to provide evidence after the fact when there's claims about retaliation against them. I think, you know, there are arguments on both sides of that, but to me, the point is, if police can, right now, attend these protests, take photos, and manually identify them, then, you know, doing that through an automated means isn't the problem. The problem is whether we want police at this protest identifying people in the first place. And so we can set policy about that without restricting overall whether police can use facial recognition to secure a facility or to identify a suspect in a shooting case or something else where there's a clearer legitimate need.
Okay, go ahead.
I would argue, actually, I think your mic's up. I would argue that it's not a matter of whether the police could do that physically at a protest, and then we should allow the technology to just make it more efficient, right? So I think both the Jones case and the Carpenter case kind of hinted to the fact that something in the technology fundamentally changes the rights that people have, right? And Harry writes quite a bit about the structural limits, right? So that it would be impractical for police to spend the time to attend every protest and manually identify every single person. And so therefore there doesn't need to be a law in order to prevent that behavior. But as you introduce a technology that radically makes it more efficient and gives the police the ability to simultaneously identify everyone at a protest, at all protests, right, if there's cameras at all of these protests, that might then require some additional limits that weren't there before.
I agree with that 100%. I wasn't trying to say that there's not something different. In fact, my point is there is something different now, and that's why we should think about passing laws to say maybe we want to put restrictions on police at protests rather than saying let's put restrictions on the facial recognition. The existence of facial recognition creates the conditions of saying we need to revisit some of these laws.
Yeah, I would also like to add something, a bit of food for thought, if you want, in this entire context. And this is also a reaction to what Meg said earlier about Rokana saying that, you know, Europe only has 2 tech companies. What do they know? I would add to that statement that, well, what Europe also has is a history of a lot of dictatorships and a lot of authoritarian governments. And they do know something about that. So the stricter regulation of personal information, the huge care about fundamental rights, and including the fundamental right to privacy, have a lot to do with that in Europe as well. So when we are having this kind of conversations, we should also keep in mind that it's so easy for governments to, at one point, switch, you know, from being a very democratic and from their respect to all fundamental rights, or to incremental make this switch. So when we are considering whether we should ban or not ban or allow this sort of mass surveillance, we have to keep that in mind as well.
Great. Yeah, and just building on that a little bit, I wonder if there's what a lot of the conversation so far today has focused on, you know, what can the government do to regulate corporations? And there was I think Meg mentioned in the earlier discussion that we should get away from a consumer focus, maybe expand our lens. And to that end, I wonder what we can learn from looking at individual acts of resistance. So in the facial recognition context, as many of you probably know, lots going on in Hong Kong at the moment. You have mass protests, you have mass surveillance, and you have mass surveillance. That is, the protesters surveying, trying to document the faces of the police in order to dox them, in order to go after them. At the same time, the protesters themselves are engaged in massive acts of what I call performative privacy resistance. They're all wearing masks, or not all of them, but many of them wearing masks, trying to avoid being subject to facial recognition technology. And I'm wondering what we can learn about those individual acts of resistance about privacy norms more generally.
just a very quick follow-up about that particular situation there. The population proved to be so innovative because I've been following news, and they're using lasers against CCTV cameras, you know, like your usual pointers, the lasers used to point on a blackboard, so that they can block that. And they are coming up with all sorts of acts of resistance that are pretty interesting to follow and see how much innovation can this type of situation bring out of the population.
I think the fact that the police themselves are covering their faces suggests, oh, this is a valuable resource here. Our faces are protecting it is important. Not being tracked is a norm which we should preserve. I want to pivot a little bit away from facial recognition. We can come back to it if need be, and talk a little bit more broadly about local and state regulations. So Reed, in the first panel, with the help of his mother, introduced us to the Ccpa, and we're lucky to have Ashkan Sultani here, who helped spur the Ccpa in California. And so, Ashkan, could you give us a brief overview of the statute, who it's targeting, and how it does so?
Sure. Thanks, everyone, for having me. So the CCPA, first off, is applies to businesses that operate in California, but is businesses over the gross and annual revenue over 25 million, or buy or sell consumers' data of at least 50,000 consumers, or derive 50% of their revenue from the buying and selling of from the selling of personal information. And personal information is defined pretty broadly, but intentionally so, to include not just what we think of traditionally as, just your name and address and social security number, but also your, say, device ID identified information. So your device ID for your phone, and other unique identifiers that companies use to identify you. And I'll talk about that probably in a second. And the law gives California consumers essentially three rights. They have the right to know, so you can go to a company, a business, and request that they tell you the information they have collected about you, as well as the categories of information that they've sold about you and to whom they've sold it. You can ask the company to opt out of the sale of your information. And what that means is that the company, let's say you visit the New York Times can use your information for showing you the ads on New York Times, but they can't sell or share that data to a third party to show you ads unless that third party is acting as a service provider and doesn't do anything further with your information. So essentially, it silos your information to the entity you're doing business with, and no other entity. For the consumers that have opted out of the sale, silos your information between you and the entity, the business you're doing business with. And so this is in the hopes of preventing a bunch of data brokers and third parties that you haven't interacted with from getting your information. To Reed's point earlier, this is preventing the secondary, not just use, but secondary collection of your information by entities that you don't have a relationship with. And then the third piece that the law provides is a kind of a right to data security. And this is really around negligent breach. So if a company breaches your information and they don't take certain steps to secure it, redact it, encrypt it, then there's a private right of action that consumers can take for the breach of that information against a company. And so it's basically one of the kind of first privacy laws. People describe it as a very broad privacy law, except it's really designed for entities you don't have a relationship with. The companies you interact with on a day-to-day basis, there's no restrictions on what they can do with your data should you provide your data to them. But of course, you can request as part of the law, request that the company delete your data after you've engaged with them. So kind of the thinking was this allows for companies to monetize your data and provide you services as you'd expect, but then curb the secondary use and secondary sharing of that information beyond that initial interaction. And so that's the law. It goes into effect in 2020, so in January of next year. Enforcement begins in the summer of next year to kind of give firms a kind of a lead-up process. The AG is to issue guidance around it. And in fact, it's not fully set. So the law was passed last year, but there's a process, the current congressional session, or the current California legislative session ends September 16th. And so while there have been a couple modifications and bills that have got through committee, there's still a chance for kind of massive, and I'm actively working to prevent massive attempts to undermine key provisions of the law, which we can talk about in the next week. So next week is when the gut and amend amendments come in through the Appropriations Committee, which is the Budget Committee that the big lobbyists can try to sneak through.
So, Ashkan, you mentioned the enforcement provisions, and earlier in the earlier panel, Reed mentioned not with respect to the CCPA, but with respect to FTC, concern that monetary penalties, when multiplied, could be debilitating to innovation and regulation. And my sense is that the CCPA sort of has the monetary penalties very similar to the Fair Debt Collection Practices Act, where there's a monetary penalty for each violation. Could you explain the enforcement procedures a little bit, and then perhaps respond to the concern from industry that this is going to be paralyzing?
Right. So so there's two kind of monetary provisions. One is as I said, the private right of action for negligent data breach, and that allows plaintiffs and others to bring cases against companies for literally negligent data breach, I think is the standard. And the reason to think about why that's important is in data breach cases, it's been tremendously hard to prove cause and prove harm around the data breach. So company A will breach your data, and then your data is then available online, say your email and your hash password, and that email and hash password is then used for what's known as credential stuffing attacks, where they access your account on a different service. So, and then your data is taken from a different service on account of the data breach from service one. And tracing that has been quite difficult, and demonstrating the link and the harm for what, these harms. So that portion has a private right of action where plaintiffs can bring their own cases. The rest of the entire law is governed by the California Attorneys General, and they can bring actions based on these based on violations of the law directly against companies. And there's a $7,500 per fine that they can bring, a maximum that they can bring per violation.
And do you think that, in terms of the risk of it stifling innovation or stifling industry, you don't think that that's?
Well, let's think about another. So we talked about early. So I used to be so I worked at the FTC. I was one of the first technologists to work at. I worked on the Facebook and Google investigations, and then I was later the chief technologist at the FTC, and I worked on the federal side as well. And one thing that's interesting is looking at this latest Facebook settlement, for example, historic settlement of $5 billion, which is the largest of the agency by like orders of magnitude, largest the agency has brought, against a company that makes something like $50 billion a year, right? And this is for Cambridge Analytica, as well as a number of other violations with regards to using your phone number under one context and then using that for advertising. So they, for example, would ask you, please provide your number for security reasons, but then they would actually sell that information or make that information available for advertising. For all the violations, including what was a very controversial blanket blanket clearance for all violations prior to the settlement date. So any other wrongdoing they may have done under the FTC Act was cleared. They paid $5 billion, right? And again, their stock price went up. The business has not changed at all in terms of their kind of business practices. And so the question is, even a fine of that magnitude, I'm not sure would stifle the direction of the company and the behavior. And I think the market responded by signaling that.
So you're saying that sometimes government lawyers and enforcement regulators are sometimes reasonable and aren't seeking necessarily to bankrupt or shut down the business necessarily.
I mean, so very much, the reason we haven't seen privacy legislation in the last 20 years is that no one wants to kill the golden goose, right? That's the language on the Hill. People recognize that this industry, this surveillance capitalism industry has generated a great deal of profit, or that's been the rhetoric, and therefore they're concerned about curbing those profits. And I think that's something we should really be kind of critical of. So in the same way that Daniel was describing the different ways where there's different applications of facial recognition, and not to lump all of them together, there's also similarly different uses of data, some of which I think have more or less privacy considerations. For example, so everyone knows that your information can be used for advertising, but your information, for example, your age, the items you searched for, where you're browsing to, that can be used to serve you ads on the page you are currently on. It's known as contextual advertising. You can do a search for bicycles and then get an ad for bicycles, and that constrains that information to only the site you're interacting with and the page you're on. Or you can profile the fact that you searched for bicycles yesterday, and then show you ads for bicycles on a bunch of different sites over time, and build a profile about you that you like bicycles, and try to serve you ads. A number of studies have come out recently to show that the benefit, for example, to publishers between behavioral advertising and contextual advertising, so the serving you of ads based on the current information versus the profiling view across sites, is 4%. So publishers like the New York Times, the Washington Post, see only a 4% benefit or an increase in revenue from behavioral advertising to contextual advertising. So the more privacy-preserving, the more privacy-violating technology only yields a 4% increase to the publishers, right? Now, advertisers pay quite a bit more for behaviorally targeted ads versus contextual ads, right? So that means that the ad tech industry, the middle layer, the people that are providing behavioral advertising, are collecting a great deal of that surplus of revenue, right? And that's why we've seen that sector of the economy, the Googles and Facebooks of the world, grow so large. And so the question we want to ask is, outside of benefiting large tech platforms, large tech advertising platforms, is the 4% increase that publishers see, right, that worth the privacy harms and privacy costs that we all experience as the result of that data collection? And I don't mean just the privacy harms in the sense that, like, now a third party has my data, right? But I also mean the fact that now that data can be used for additional government surveillance, which a lot of my work, I also worked on the Snowden files, demonstrated that the NSA, for example, was using commercial data for targeting and tracking of individuals. So that data also increases government surveillance. It also increases essentially this drive for micro-targeting to both reduce public health around addiction and engagement with applications, but also the ability for foreign actors to micro-target and manipulate people based on their profiles, right? So now you have harm not just from the collection of information, but increased surveillance, reduced public health, and now national security. And so are all those things worth 4%, is the question, to publishers? Or should we kind of say, well, maybe there is a great deal of value and innovation in the models in advertising, but maybe we could push to a more privacy-preserving versions of advertising. And so contextual is one. There are also a number of other companies that are emerging, that are innovating now that there are privacy laws, to try to innovate around ways to do targeted advertising without revealing your information to third parties. So the Brave browser, some folks might have heard of, it's an alternative to Safari and Chrome and Firefox. They are trying to experiment with technologies to allow profiling only on your local device without sharing your information with others, so that advertisers don't receive indication of what information what you're interested in, but you can still see ads that are relevant. So I guess as a general matter, I think yes, there are some impacts to innovation, but I think and there's some potential impacts to revenue. But one, it might be worth it, and two, I don't think that it's kind of a blanket on or off. There might be lines in which there are areas where we might say this is workable, and we can draw it back. And one final point to kind of echo something Ryan said, which is that we absolutely can decide the world we want to live in terms of the use of this technology and the application of this technology. And it's really critical to remember that the whole paradigm we're under, which essentially allows the free flow of information from, for example, the website you visit to all these other third parties that collect your data, that was decided by essentially a browser engineer about 15 to 20 years ago, when they decided to allow third-party cookies to be set without getting consent. That was literally an engineering decision to facilitate things like shopping carts and single sign-on the web. And that single kind of decision gave rise to this huge advertising industry, as well as this economy of your data going everywhere. We can decide that wasn't such a great decision, and maybe we want to add kind of restrictions to it and in certain ways and limit that behavior, and knowing well that it wasn't that intentional of a decision anyway.
Just to bring it back a little bit to Daniel's comments, and building off your last point, Ashkan, I mean, in the facial recognition context, but in so many contexts, there's this tension between, okay, can we actually design effective privacy protections, or should we not rely on technology to be the solution to the problems, but instead rely on, broader legal interventions such as bans to solve these kinds of problems? Or does it vary depending on the context? Anyone, including Ashkan?
I mean, if you look at, so the closest corollary to this is environmental regulation, right? Both in terms of the public health benefit, both in terms of the state action followed by federal action, both in terms of taking a resource that was previously unrestricted and then putting regulation on both the collection of that resource and the emissions resulting from that resource. And the thing to think about it is you have both law and technology working in tandem in that context as well, right? You have some restrictions on, for example, the use and the collection of the resource. You have restrictions on the emissions and standards, and then you have promotion of certain technologies that are, for example, more pro-environmentally beneficial, right? So you have both the law and then you have kind of technologies that help support the law, and I think that works quite well.
To add to that, Ashkan, you can have laws that actually promote privacy-friendly technologies. And we've seen that happening with the GDPR. So not only that the GDPR has a specific legal obligation now for data protection by design and by default under Article 25, but we've seen an entire new tech sector emerging, privacy tech. It had a spectacular growth in the past year or so. We've already seen the first unicorn, how are they called? A company that used to raise more than $1 billion specifically for privacy tech. But we've also seen, and this is also a bit of a reaction to Gus's intervention in the earlier panel, saying that the GDPR strangled innovation in Europe. The other side of that coin is that we've seen so many startups and so many companies that build their business model on protecting privacy. And Ashkan already mentioned some of those, but there are also email service providers that are starting to grow. And this is, the other side of the coin.
Yeah. I think, an imperfect example of that maybe many of us are familiar with is Apple itself. Apple, markets itself as being, they have these commercials with the apple turning into a lock or the lock turning into the apple. They are using privacy as a selling point relative to Android devices. So California, as in the environmental context, is in many ways leading the way in terms of regulatory approaches, but they're not alone. And we're lucky to have Dan from the Colorado Attorney General's office here to talk to us a little bit about the existing data protection law that was passed last year and future potential endeavors that are going to be occurring here in Colorado.
Thanks, Scott. I will not ask you to pronounce my last name again. So first I want to start by thanking Silicon Flatirons for having us here and for convening such a wonderful group of experts. We really draw significantly from our colleagues that come here, and we appreciate the input that we get as a governmental regulator from the privacy community at large. So thank you all for that. I'll talk first about some of our efforts, our initial efforts in what I'll call data protection, but I'll also lump that into privacy more generally. So in 2018, we passed House Bill 1128. It went into effect. HB 1128 requires reasonable security procedures to protect personal identifying information given the nature and context of your business. Pretty reasonable requirement. Well, that wasn't on the books before HB 1128. In addition to that, it requires a written policy for disposing of personal identifying information, both in digital form and in physical form. Again, this was not something we were mandating our companies to do. And then finally, it created a data breach notification requirement to report both to the consumer and to the Attorney General's office within 30 days if their PII was breached. And some of the things that the businesses are required to report include the nature of the personal information, include the date of the breach, and to the Attorney General's office, they have to talk about the number of Colorado consumers affected. There is a triggering limit. If over 500 consumers are affected, that requires notice to the Colorado AG's office. So what have we done here? I would say we've established a baseline for data protection and for data privacy in the state of Colorado. We can do better, we can go further, but this is a really good start. So I've had the privilege of serving under 3 attorneys general, John Suthers, Cynthia Kaufman, and now Phil Weiser. We didn't do much around privacy and data protection under AG Suthers. I only worked for him for a couple years. Under AG Kaufman, we had a HB 1128 passed, providing a foundation and providing a baseline for the handling and disposal of personal information, requiring the breach notifications. Under Attorney General Weiser, I expect we will take that to the next level. Now, I don't know if that means more restrictive. I don't know if that means an omnibus law. I don't know if that means sectoral law. But I do want to say we are considering it. Let me start by talking about the effect of the data breach notification law. So it's been in place for about a year, requiring notifications. And so I'll give you some overarching numbers. Between August 1st and December 31st of last year, we had 27 reported data breaches affecting 78,830 Colorado consumers. In the first 8 months of this year, we have had 62 reports of data breaches affecting 590,485 Colorado consumers. It's 10% of the population of the state of Colorado. And those are the people that are reporting. And quite frankly, I look at those reporting as good actors because they're in compliance with the statute. What we're really concerned about is people that aren't reporting, people that know they've had a breach, people that are aware of the law, and people that are acting in bad faith and intentionally not reporting and covering up these breaches. We feel like notice to the consumer and notice to the state is really important in that context. Some other information we've been able to derive from the data breach reports. Top methods of intrusion or compromise. Number one, obviously phishing. That makes up the vast majority of the methods of intrusion. Point of sale malware is also a popular compromise. And then access to an email account with personal identifying information. So we're getting an idea of where the areas of vulnerability are. We're getting an idea of what we can do to better protect consumer information, and it's giving us some insight into maybe what sort of laws and regulations that we should mandate. Another really great thing about the law that we passed is it applies to both businesses and the government. And I would hope the business community would be fond of that provision because it means we have to drink our own champagne. So, and you know, I think that's totally reasonable. If we're going to sit up there and we're going to write laws demanding that companies handle PII and dispose of PII in a certain way, that should absolutely apply to the governmental sector as well. And so I don't think it's a secret that Attorney General Weiser is looking at and contemplating and researching the possibility of other data privacy regulations. We've got a lot of stakeholders in this area. We've got a lot of people that have a lot of different opinions, a lot of different views, and we want to hear from all of you. And so I'll take this opportunity to disseminate a public-facing email address. So if anybody wants to give feedback on potential Colorado privacy legislation, if anybody has any ideas or thoughts or has anything they want us to contemplate, the email address is privacy@coag.gov. Privacy@coag.gov. And that will come to our office, and we'll certainly look at it, we'll certainly consider it, and we'll certainly take it into account.
Thank you, Dan. So one issue that was raised in the earlier panel and is also highlighted by Ashkan and Dan's presentation about the different state laws at issue is that, the U.S. approach is highly fractured. And so, Gabriella, I was wondering if you could tell us a little bit about whether or not you think the fractured regulatory environment is problematic and what the United States has to learn from what's gone on in Europe with the GDPR.
Thank you for the question, Scott, and thank you to Silicon Flatirons for the invitation. This has been a great day until now. Now let's see. So it's this is perfect that you mentioned, Daniel, the data breach notifications that you receive here in Colorado, because as we know in the United States, there are approximately 50 data breach notification laws. And speaking of costs of fragmentation of regulation, I found a figure from a study published last year about average cost of a data breach in some of the major economies in the world. And there was no surprise there that the United States had the first place with an average cost of $7.91 million per data breach. The second in that ranking was Canada with 4.74, and then the third, Germany, with $4.67 million per data breach. And it's easy to make the connection that having to deal with 50 different data breach notification laws has something to do with that. Looking now back to Europe, I have to say that fragmentation of how the former Directive 95/46, so the Data Protection Directive, was being transposed at national level in member states in the EU was one of the two big reasons for the existence of the GDPR, so for the proposal of the GDPR. It was really so important that there's actually a recital in the GDPR, it's recital 9, which recognizes the fact that the differences at member state level of implementing and applying the former directive was one of the reasons why the GDPR was proposed. Because, so it notes, I'm sorry, I'm reading, I have to quote from this, it notes that this fragmentation may constitute an obstacle to the pursuit of economic activities at the level of the union, may distort competition, and also impede authorities in the discharge of their responsibilities under union law. And this is due to the existence of differences in the implementation application of the directive. So this fragmentation was a big reason for the GDPR, but when I compare the situation to the US, it's very interesting to note that even though at member state level there were differences in transposition of the directive, nevertheless, the core principles of the directive were the same. So don't think that the differences were so big between, let's say, France and Germany and Romania and Estonia that it created a disaster. The differences were actually in the details. However, even that was considering as stifling data flows within the single market, as Meg mentioned earlier. That was that's one of the big drivers of having a data protection regime at European Union level, allowing for free data flows within the single market. The other big drive of that is the protection of fundamental rights at the same level of protection across the European Union. And with that, I want to go back to one of the questions received earlier by the panel, suggesting that we should think of privacy as being a right to privacy. And I would have to say that the reason for the big differences between the regulatory model in the European Union and the regulatory model here over data, personal data, is the fact that in Europe, we recognize not only the right to privacy as a fundamental right, but also a different right, the right to the protection of personal data. That's protected separately. So we have an Article 7 in the EU Charter of Fundamental Rights on privacy, and an Article 8 on the right to the protection of personal data. The reason why I bring this into the conversation, and I will finish with this last point, is that looking at the distinction between having a ban type of regulation and a rules of the road type of regulation, well, in Europe, this is what we have with the two fundamental rights. So the right to privacy, as it is protected under Article 7 of the Charter, is meant to be a sort of an opacity regulatory tool. It's meant to ban, even though that's not really a word that's used there, but it's meant to restrict to the extent possible and ban to the extent possible any intrusions into one's private sphere, intimate sphere. So it's meant to work as an opacity cloak, if you want, over one's private sphere. And then the right to personal data protection and the legislation that follows from that right, so the GDPR, is a rules of the road type of legislation, allowing the use of personal data, allowing the collection of personal data, but with justifications. But those justifications are quite wide if we look closely at them. But just setting rules on how that data can be used and setting specific rights for individuals to access their data, ask for erasure, and so on. So this was just to give you a bit of a flavor of what's happening in Europe and the philosophy that underpins all of that over the ocean.
Thank you, Gabriella. Super fascinating. So we've got about 10 to 15 minutes left, 10 minutes left. So I'll open it up to questions, and we will, again, start with a student. I see many of you. So, yeah, in the back.
I'm curious as to the difference between GDPR if you're using data. It doesn't really matter where your company is based in the world. And I'm curious if your California law will base itself on companies based in California or companies that have customers in California.
So the question was, in effect, I think, whether or not the CCPA, the California law, has a territorial limitation to it. Is it limited to people based in California or not?
It's people based in California. It's a right to protect consumers.
Yeah, I don't mean the people. I mean, is it regulating all? Or is it regulating only companies based in California?
No, it's not regulating. Sorry, Ashkan, for
Right.
taking over like that. I told you it's been good until now, but it's regulating businesses, companies doing business in California that collect personal information of residents of California. And this is very interesting here. This is a very interesting nuance because the CCPA, it's the California Consumer Privacy Act, so it refers to consumers. But if you look at the definition of who is a consumer, technically you only have to be a resident of California to be a consumer. So that's very interesting, and it actually generated a lot of interesting discussions and debates on whether the fact that employees are also covered, and as it's currently drafted, it seems they're covered, so personal information of the employees who are not consumers in your regular understanding.
Right.
Just a added point on that. This brilliant scholar has come out with a paper about the potential California effect of the side effects and the spread of this. I can't remember her name. Margot Kaminsky. So check that out.
Yes.
I'm David Ray. I'm COO and General Counsel of a facial recognition technology company based here in Denver. I'm David Ray. I'm COO and General Counsel of a face recognition technology company. So I've got a few things. So one, to Rebecca's point, there's not an actual case of any actual harm from face recognition in the U.S. of anyone being misarrested or misimprisoned due to automated face recognition. There's one case actually here in Colorado, but it's if you look at the facts, it's a human examiner. There was a bank robber, and his wife called. The bank robber footage went out on Crime Stoppers. The guy's wife called and said, "That's my husband." And then the FBI human face examiner said, "Yeah, it matches. I mean, it's a doppelganger," but it wasn't automated. So there's not a single case of that, but we're regulating this based on people watching too much Black Mirror and Minority Report of what is the potential harm from mass surveillance, which is also not how police are using it. Kind of to Daniel's point, police are using face recognition very analogously to fingerprints right now. Perpetrator comes, commits a crime, leaves a fingerprint, the police dust, find the fingerprint, run it against the FBI database to try to figure out who done it. And similarly, here, a perpetrator, a bystander captures a picture of somebody leaving an assault, or there's a security camera footage. Police are using that imagery to search against their mugshot database or their driver's license database if they have access to it. And it's to generate investigative leads to try to solve crime. It's not mass surveillance. It's not meant to chill civil liberties, which kind of brings me to my next, and I'm going to get to a question here. So kind of Scott's point and Gabriella's point is we talk about totalitarian dictatorships, totalitarian governments. Its use in China, its use, if it were under, a Nazi regime or a totalitarian government. And yes, all technology, all tools will be used in totalitarian governments to control their population. But we live in America. We have the Constitution, we have the Bill of Rights. And to me, it's a real sense of fragility around our democracy and our American way of life and our Bill of Rights, our civil liberties. I think to Daniel's point, we should be looking at that. How can we really protect those things, not ban the technology, which is not really nailing hitting the nail on the head. So my question there is, how can we have a rational discussion about this technology without kind of dealing with sci-fi and what ifs? What if America were not American? The police were out to track every single free speech person and lock them up. I mean, I guess it's feasible.
I think we get the thrust of your question. I'm gonna,
Thanks.
let folks respond, and then I'll take 2 more questions.
All right. First, you don't want to use fingerprints as a rhetorical device because there's been so many examples of fingerprint technology being used to misidentify people. So that's not going to be helpful to your point. So the question of when to regulate new technology when you see potential benefits to it for particular use cases, or you see potential harms from other either bad actors or indifferent actors, or people motivated to monetize it in some way. Like this is one of the fundamental tech law questions, right? And you're always going to have this potential spectrum of responses. On one side is the precautionary principle. We can see this upcoming risk. Let's avoid it, right? Let's try and regulate ex ante and try to prevent that risk from happening. On the other side, you've got the procrastination principle, which says, hey, let's wait and see what harms manifest, and then we can deal with them, right? We can have responsive regulation to address those harms as they occur, either through the court system or through, as I sort of referred to earlier, in response to a major accident. Somewhere in the middle is proactive regulation, right? Regulation that says, okay, we can anticipate these specific kinds of harms, and we see that their risks outweigh the benefits. And so we can try and have regulation that still allows for innovation, right? And sometimes actually regulation can spur innovation, as you were implying with the GDPR. And try and minimize those harms before they become entrenched, right? Before we get the mass amounts of pollution that we have that might have been predictable had there been a bit more of analysis before of certain kinds of technologies. This is the debate. Like, this is the conversation we need to be having. So to say, how can we have this conversation? It's like, this is exactly what we need to be discussing.
Questions. You, and then right behind you.
So wiretaps are an incredibly useful law enforcement device, but we don't allow bulk wiretap surveillance. So to the previous point, it seems like the proactive regulation that we might need could draw from that model of, it's a matter of scale rather than a matter of ability. It's easy to do bulk wiretapping, but we don't let people do it. But my real question was actually about the CCPA. The way that it seems to have come out, the right for controlling the onward movement of data is a bit of a closing the stable door after the horse is bolted, opt-out model. Surely if we really care about privacy, we should be going for opt-in models.
So,
Great, and just one second, let me get the second question.
So
No, behind you.
Hi, my question is for Ashkan, and my question is, does the CCPA extend to healthcare data as well? Many states are developing care coordination networks, often collecting that data without explicit consumer consent and knowledge. And does your law protect individuals in that regard?
sure. And just to clear, it's not my law. I was advisor on, I was brought in to help on some of these matters. On the second question, information collected pursuant to HIPAA, GLBA, also I think drivers, some automobile information. There's carve-outs for those. So HIPAA covered information, information covered under HIPAA would be excluded from CCPA. However, health information does not fall under HIPAA would be covered by CCPA. To your question of opt-in versus opt-out, I think that's a great question. It was a huge debate. I also used to think opt-in is the way, except that as we see in Europe, most people just opt in. If it's between seeing like cute cats playing on YouTube or giving my data, most people will opt in to that choice. And furthermore, people get click fatigue if every site requests an opt-in. So the model of CCPA has two features. One is that you can opt out from the site selling your information using a button that the site provides. They have to prominently display do not sell my information. But there's a not well-known piece in the CCPA. And so some background, I used to work on do not track as well when I was at the FTC. And so there's a piece in the CCPA that says you can allow a third-party person to opt out for you. And our intent with that was that the browser manufacturers or even your operating system or your phone could provide an opt-out mechanism to essentially opt you out of a number of services, and therefore you have a blanket opt-out. Additionally, there's a provision in the CCPA that says companies cannot deny you service for your opt-out. So they can't say you can't use our website. There are some provisions where they can essentially charge you the value of your information, the value they would lose from monetizing your information, but that value has to be directly related to the difference in contextual ads versus behavioral ads, which I described, which is about 4%. So they could charge you potentially 4% more. And that's up to the AG to bless. But
Great. Well, we're going to move from this panel directly to our keynote speaker, Commissioner Slaughter. So keep your seats if you can, and we'll have lunch in 30 minutes. But now, join me in thanking the panel.